Thank you very much, Mr. Chairman, Solicitor General Kagan. You had an incredibly grueling day yesterday and did incredibly well, but I guess it means you missed the midnight debut of the third Twilight movie last night. We did not miss it in our household, and it culminated in 3 15-year-old girls sleeping over at 3 a.m. So I have this urge to ask you about the
I didn't see that.
I just had a feeling. I keep wanting to ask you about the famous case of Edward versus Jacob, or the vampire versus the werewolf. But
I wish you wouldn't.
I will refrain. Well, I know you can't comment on future cases, so I'll leave that alone. I read a few weeks ago this article that I thought was good in the Washington Post by Donald Ayer, who is the former Deputy Solicitor General in the Reagan administration. And he talks a lot about what he thinks these hearings should be about. But he also makes some references to the balls and strikes analogy. And as you know, when Chief Justice Roberts was nominated to the Supreme Court and sat in the seat you're currently in, he famously told this committee that judges are like umpires. Umpires don't make the rules, they apply them. He said that it was his job to call balls and strikes. And I was wondering if you could just talk about that metaphor. Do you think the balls and strikes analogy is a useful one, and does it have its limits?
Senator Klobuchar, I think it's correct in several important respects, but like all metaphors, it does have its limits. So let me start with the ways in which I think it's an apt metaphor. The first is kind of the most obvious, which is that you expect that the judge, as you expect the umpire, not to have a team in the game. In other words, not to come onto the field rooting for one team or another. You know, if the umpire comes on and says, you know, I want every call to go to the Phillies, that's a bad umpire. And is that your team?
Not exactly. The Twins.
I was pointing to Senator Kagan. I'm sorry. And same for the judge. So you know, to the extent that what the umpire suggests, that there's got to be neutrality, that there's got to be fairness to both parties, of course that's right. The second thing that I think is right about the metaphor, and I think that this is what the Chief Justice most had in mind, if I remember his testimony correctly, is that judges should realize that they're not the most important people in our democratic system of government. They have an important role. Of course they do. We live in a constitutional democracy, not a pure democracy. And judges have an important role in policing the constitutional boundaries of our system and ensuring that governmental actors, other governmental actors, don't overstep their proper role. But judges should recognize that that's a limited role, and that the policymakers of this country and that the people who make the fundamental decisions for this country are the people and their elected representatives, whether in Congress or in the executive branch. And I think that that's right, too, as I've tried to say on many occasions throughout these hearings. I suppose the way in which I think that the metaphor does have its limits, and I believe that this is in line with what Mr. Ayers was talking about, was that the metaphor might suggest to some people that law is a kind of robotic enterprise, that there's a kind of automatic quality to it, that it's easy, that we just sort of stand there and, you know, we go ball and strike and everything is clear cut, and that there's no judgment in the process. And I do think that that's not right, and it's especially not right at the Supreme Court level, where the hardest cases go, and the cases that have been the subject of most dispute go. And as to that, I think that there is, judges do, in many of these cases, have to exercise judgment. They're not easy calls. That doesn't mean that they're doing anything other than applying law. I said yesterday on a couple of different occasions, it's law all the way down. You know, you're looking at text, you're looking at structure, you're looking at history, you're looking at precedent. You're looking at law and only at law, not your political preferences, not your personal preferences. But we do know that not every case is decided 9-0, and that's not because anybody's acting in bad faith. It's because those legal judgments are ones in which reasonable people can reasonably disagree sometimes. And so in that sense, law does require a kind of judgment, a kind of a wisdom. And there are frequently clashes of constitutional values. Senator Whitehouse talked about one such clash, but there are many of them. And judges have to, listen to both sides and cast each argument in the best possible light, but sometimes they're not going to agree.
And one of the things he says in this article, he makes that point and talks about how these hearings should actually focus not on what he calls the simple cleverness and ability to score debaters' points, but of greater relevance when you look at the whole universe of trying to make decisions between plausible alternatives on different cases. He says the greatest relevance for a nominee is a demonstrated history of good judgment and prudence in life as in legal work, and he makes the argument that that should be the focus of those hearings. So along these lines, I'm going to just ask some of your work experiences and how you think that they help you to be a better judge and what you bring to the bench because of that. Senator Schumer had asked you about your work as dean of Harvard Law School, and you said the thing you learned most from that was listening. And I wondered, how will that experience beyond listening even, what will you bring from that experience to the bench, and what lessons have you learned that will make you a good justice?
Well, Senator Klobuchar, I guess I'll start by just saying that listening was the most important lesson. I was so struck when I read this statement by Justice Stevens about understanding before disagreeing, and he had said that about the justice whom he clerked for. And I thought, that's about the best thing that you can say about a person, that the person does listen and try to understand things from the other point of view before deciding to disagree, and, maybe deciding not to disagree because of the listening and the understanding that's taken place. So that's I hope, something that I had to learn a little bit during my time as dean. But I guess otherwise, Mr. Ayers said prudence and judgment. I do think that when you run an institution with many employees, with a big budget, with just lots of the kinds of problems that any person who runs a business or runs an organization just knows the wide variety of things that come across your plate every day, and you exercise a lot of muscles when you do something like that, and they're muscles that I had never exercised before, and it gave me grounding in a lot of things that I otherwise would not have had grounding in. And it made me, I think, very aware of other people, I think, in a way that maybe I wouldn't have been had I been just a professor all my life, because so many people come to your office with just life problems, and you get exposure to so many different sorts of issues that people are struggling with and that people are confronting in their lives, and it becomes a little bit your life too, and I hope that made me a better person.
As a Solicitor General, you got to actually argue cases before the Supreme Court. And how has that experience informed your appreciation for oral argument and what you think are good oral arguments, bad? What techniques do you think work?
Well, first I'll say that it's very much deepened my appreciation of the court itself, and I hope that this was something that I conveyed in my opening statement, is that you go up there and you get to the podium, and there are 9 people, and every single one of them is so prepared to talk about the case, so into the case, so engaged, obviously so smart, and so, I think, trying to get it right. And so I've developed a real appreciation for the court through those oral arguments. What do I think is a good oral argument? I think I think you have to answer the judge's questions. I think they're impatient when people try to give speeches or when people go up to the podium and just try to make their points. I have 4 points I want to make. I'm going to make those points again and again and again. And the justices, I think, they have your briefs. They've read your briefs, and the striking thing is that they really have read your briefs. They know your briefs, so they don't want to hear you repeat your briefs. What they want to hear you do is respond to their questions. And I think good advocates know that, and they know that even if it means going down a road that their great points are in some other direction, but it makes sense to go down the road that the court wants you to go down, because that's what the court is interested in, and it's only if you address the justice's real concerns that you're going to win your case.
So if you are confirmed, then we will consider those tips for those that go before you. The other thing I wanted to get to, back to this judicial philosophy piece of what we're talking about here, and that is this back to the master's thesis you wrote. I know it was before you were in law school, as you and Senator Grassley discussed. But in that thesis, you wrote that Supreme Court justices live in the knowledge that they have the authority either to command or to block great social, political, and economic change. At times, the temptation to wield this power becomes irresistible. What in your character or your experience will help you deal with this temptation when you're on the bench?
Well, I again want to say what I said yesterday is that let's just throw that piece of work in the trash. Why don't we? That it was something that I wrote before I went to law school and didn't know much, didn't understand much about law, and certainly about the way judges should work. I just think every judge just has to be committed to the kind of principles of restraint that I've tried to talk about in this hearing, and every judge has to realize that the people of this country get to make the fundamental decisions about this country. And I do think that my experience working in other branches of government, in the executive, and working a good deal with Congress, will remind me of that, if anything were needed to remind me of that. Because what I did take away from those experiences was really a profound respect for the political process and for how policy decisions are made. And not every single one of them looks pretty. And of course, no single person is going to agree with every result that comes out of Congress or any other political institution. But I do believe that there is real wisdom in the American people, and that wisdom gets channeled through institutions like this one, and that in the main, we are well served by our political institutions, and that even when we're not, it's just not up to courts to correct that. So, I think that the experiences that I've had in government are good reminders of just the importance of the democratic branches of our government in making the fundamental policy decisions that affect our country.
Very good. The other part of your job will be to write opinions. And in a 1996 article on the First Amendment, you discussed a case actually from my state, RAV versus City of St. Paul. And you've noted that Justice Stevens criticized part of the Supreme Court's approach in that case, characterizing it as, quote, an adventure in a doctrinal wonderland. How, as Justice Stevens' successor, would you work to make sure the Supreme Court's opinions are both well-grounded and accessible to the general public?
Senator Klobuchar, I think I should say it's an important question. I'll just say I think in the end I disagreed with Justice Stevens more than I agreed with him in that opinion. But I do think it's sometimes a fair criticism, the criticism that Justice Stevens made, and it suggests something about maybe some decisions' lack of connectedness to sort of facts on the ground. And And I would say two things about that. I mean, the first is that courts have to be really attentive to the facts of a case, that courts can't be sort of spinning legal doctrine irrespective of the facts in a case that have been presented to them. Because the whole idea of courts in our system is that courts aren't deciding abstract legal questions. They're not just sort of philosophizing about proper legal approaches. They're deciding actual cases and controversies. And what it means to decide an actual case or controversy is to think about the application of law to facts. And what that requires is that you really understand the facts, that you really that you delve through the record, that you get your absolute best sense of what the actual conditions and circumstances of the parties are. So that would be the first point I would make. I guess the second thing is actually that even going beyond that, that it's often an important part of principal judicial decision making to take into account the actual consequences of a legal rule. And this appears in a number of different areas. I'll give you one, which is procedural due process, the 14th Amendment. We're more used to talking in these hearings about the substantive due process aspect of the 14th Amendment, but the procedural due process aspect is very important. It's the set of requirements that say when an individual comes and challenges the government, says the government has denied me some benefit that the government owes me, the question is what procedures is that person entitled to make that challenge? And the test the court uses is a very practical one. It says, well, if we gave you more procedures, how much would that increase the accuracy of our determinations? And also, if you were wrongly deprived of some benefit, how much would that hurt you? And also, what's the burden that these procedures are likely to impose on the government? Like, what's the actual cost that the government is going to have to incur? And it balances those things. And that's an example of how, in some areas, the court has, and I think has appropriately, looked to the real world, the practical effects of a particular legal rule.
All right, so you're not talking about driving a result, you're talking about how the results, knowing what the results could be, should be considered.
Yes, you're totally not talking about driving the results. This is anything but a results orientation in the way people sort of think, oh, I want this side rather than that side to win. That's inappropriate in every and all circumstance. But there are places in which the legal doctrine and even the constitutional doctrine does take into account practical effects. I mean, and just another quick example is Fourth Amendment search and seizure cases, where the Constitution speaks of unreasonable searches and seizures. And one of the things that the court takes into account in deciding what's a reasonable search and seizure and what's an unreasonable search and seizure is some practical impacts on the people who are searched, but also very much on the police. You know, how can we create a set of, how can we create a doctrine that the police will find to be workable so that they'll know when to search and when not to search, when they have to get a warrant and when they don't have to get a warrant.
Well, and along those lines, last year the Supreme Court decided, as you know, Melendez-Diaz v. Massachusetts, a case about the Confrontation Clause in the Sixth Amendment. And the court held that it violated the Confrontation Clause for a prosecutor to submit a chemical drug test report without the testimony of a forensic scientist. It was a 5-4 decision. It didn't split along long ideological lines. And I was concerned about the decision just because, again, of the practicality of how all this would work for prosecutors. And actually, this year the Supreme Court had another case, Briscoe v. Virginia, which raised the same question. And I was hopeful that the court might limit Melendez-Diaz. 26 attorney generals, including the Attorney General of Minnesota, chimed in explaining that it was already negatively affecting drug prosecutions in some states. And actually, as Solicitor General in the Briscoe case, you submitted an amicus brief that supported the position of the state. And I thought you could discuss this, elaborate on the position. and why you think it's important. If you look, because I figure you're not going to be able to get involved in this case if you're a justice, but just if you could talk about the results and what could happen with a case like this.
Well, I won't be able to get involved in this case. I'm sure that there are other issues that will be coming down the road about the Confrontation Clause. I'll try to steer clear of that. As you say, Senator Klobuchar, the United States government did file a brief in that case, and it supported the, whatever it was, 26 or 27 states, which were concerned about the effects of the court's prior ruling on law enforcement, and particularly were concerned about the ability of governments to present evidence. This was evidence of drug testing without going to great expense and burden to get every lab analyst into the courtroom.
Right. I think in Virginia the statute said they could bring them in if there was a question, if it was disputed. But if it wasn't disputed, they didn't have to bring the lab analysts in.
That's
and the Supreme Court decided not even to go into that and say, well, that would be fine.
Yeah, I think that the court just remanded the case back to the lower courts to decide it, and decided, not to say anything more about this issue in that case. We had, the government had urged them to do so because of the kinds of practical issues you raised. I think, the court's analysis in this area does not focus on those practical questions. The court's analysis simply says, is the evidence in question testimonial, which an affidavit from a drug analyst would be? And if it's testimonial, the only way in which it can be admitted in court is if the person who has made the affidavit, who has written the affidavit, is unavailable and was previously subject to cross-examination. So it's a pretty bright line rule, and it has had the effects on states that you mentioned, but it is the approach is now settled law. And I will say one thing about this. I think it sort of suggests something different about the judicial process that is a point I've been trying to emphasize. I think that the justice who has been primarily responsible for this understanding of the Confrontation Clause, and it is an understanding of the Confrontation Clause that's, that works well for criminal defendants.
That's a nice way of saying it.
Yeah, I mean, criminal defendants love this rule. Prosecutors do not like this rule. The person who has been most responsible for this approach is I think Justice Scalia, and I don't think that Justice Scalia is any great fan of, if you gave him a criminal defendant and gave him a prosecutor and said choose. I don't, I think we'd know which way he'd choose. I think it's actually a good example of where a person's view of the law comes out a different way from, which party they might want to have win. And that's a great thing for a judge to do. I mean, all judges, that should happen in their lives, that their view of the law leads them in a direction which, if they were a legislator or if they wouldn't come out that way.
Well, I just hope you'll take to heart one of the comments written about Justice O'Connor when she retired. Someone said, on an attentive reading, many of the justices' opinions were infused with a keen sense of what it felt like to live inside the shoes of affected litigants and ordinary citizens, and with an almost urgent need to make certain that the outcome of the case, while doctrinally sound, was also workable. And they went on to talk about her approach and a focus on pragmatism. And when I think about this Melendez-Diaz case and some of the other ones before the court, in addition to some of the other issues my colleagues have raised, and this is not an ideological argument, it's just a practical argument of having someone that'll go in there and think about the effect that some of these decisions have on ordinary citizens. So I hope you'll take that to heart. Last thing I wanted to ask is the daughter of a former reporter. It's just about, there's been a lot of talk about the First Amendment as it relates to political speech. But I just want to talk for a minute on New York Times versus Sullivan. And in 1993, You wrote a book review, and you discussed the Supreme Court's decision in that case, which, as you know, was a critically important decision for libel law and for the First Amendment specifically. And your 1993 piece recognized how important the Sullivan decision was for First Amendment jurisprudence, but discussed the fact that the actual malice standard had been applied in libel cases that differed a great deal from those facts in Sullivan back in the 1960s with the Civil Rights Movement. You wrote in that review that, quote, the obvious dark side of the Sullivan standard is that it allows grievous reputational injury to occur without monetary compensation or any other effective remedy. And you wondered, is uninhibited defamatory comment an unambiguous social good? That is, does it truly enhance public discourse, you asked. And I wondered if you agreed with your past comments on Sullivan and whether or not your last few months going through the media focus with your confirmation hearing has changed your opinion or strengthened it in any way. Solicitor General.
Okay. I think people should be able to write anything that they want about me, and I don't think that I should be able to sue them for libel.
Very good. But how about the case itself, and with the changing internet and other, more social media and bloggers? I mean, does that affect anything? And how about your past comments? Do you want to add to those from the book review?
It's been a long time since I read that book review, but I think that the point that the book review was making was, on the one hand, what an iconic decision New York Times versus Sullivan is, how important it's been to the development of our First Amendment law, how vital it is to a system of free expression, to have newspapers and other people who speak. It's not just newspapers, as you suggest. I mean, given the way the media has developed, there are so many different ways to express thoughts in our world now, and to have these speakers insulated from libel suits by people who are in this public sphere, who are public officials or who are public figures, and to have an extremely high bar before those people can recover for any libel that may have been done them. I guess the question that I was asking in that review, and I continue to think it's a real question, is how far should that go, in the sense of we should understand that libel can harm people, that reputational harm is real harm, and that people can suffer great damage from their reputations being inaccurately besmirched through utterly false statements. And I guess the question that I asked was whether there were some contexts where the person had not put themselves into the public sphere in any real way, where the person was, a private actor trying to mind his or her own business and sort of became dragged into the spotlight and something terrible said about that person in a way that had harmed that person. The law actually does treat that person somewhat differently in libel law, but the question I was asking was whether the balance had been struck appropriately in that sort of case, where the values of the First Amendment in uninhibited political speech are not so much evident, and where the personal harm can be great. And it's been so many years since I read that article. I'm not exactly sure how I came out on that question, but I think it's a real question. And even as we understand the absolute necessity for a kind of New York Times versus Sullivan sort of rule, and for protection of speakers from libel suits, from defamation suits, even as we understand that, we should also appreciate that people who did nothing to ask for trouble, who didn't put themselves into the public sphere, can be greatly harmed by when something goes around the internet and everybody believes something false about a person. That's a real harm, and the legal system should not pretend that it's not.
Well, thank you very much, and thank you for putting yourself in the public sphere today. And as I said at the beginning, you've done a very good job. Appreciate it.
Thank you.